Should be okay.
Sure. The usually when there's multiple burglaries, and based on the defendant's history, I felt like an offer of 5 years with 2 years to serve was appropriate. And so that was the offer that I sent to Mr. Duttweiler. He subsequently emailed me to, sometimes he'll email me and say, okay, but how about this? Would you consider this? And so then he emailed me and asked me about ITF. He said that there were some possible mental health concerns with the defendant. And so I said, that sounds like a good idea. And so we agreed that it would be 5-2 and that we would add, that we would recommend that the defendant be sentenced to ITF so that he could get the help that he needed. Drug court or health court wouldn't have been an option in this case because of the defendant's history. He would have needed more structure than a drug court program.
Is it your understanding in regards to the IFT program that is something you can make part of the recommendation and the court can make part of the sentence technically as the court did in this case, but it's ultimately up to GDC and their screening process as to whether they will determine a specific defendant qualifies?
Yes.
There was some talk at the beginning of our hearing today about a Scrivener's error in Mr. Webb's sentence, that his one sentence actually says 3 years in confinement, but it should say 2. Do you have a recollection of that?
Yes. So I looked over the transcript from the plea and I saw that we didn't make the best record. His case was closed on a duty day, and I did personally handle it, but it was not in the actual 5-2 was not stated in the transcript. However, on the duty days, the plea offer is actually handed up to the sentencing judge as well as to his sentencing clerk. So the judge would have had that 5-2 plea offer in front of him, because I always have the offer in my file. I have the right number of copies, and then I hand it up to the judge and the sentencing clerk. So he would have had that, and it should have been 5-2. And I think it was just they got it backwards, the 3 instead of the 2.
Okay. It's my understanding that you and Mr. Duttweiler are in the process of correcting that mistake.
Yes. I reached out to him about that yesterday.
Do we have a timeline for getting that fixed?
Oh, it will be very soon. Mr. Duttweiler's staff is very efficient. So his secretary, Kathy Gibbs, will prepare a consent order, and we'll submit it to Judge Oliver.
Would you be able to get a copy of that to Mr. Webb and his current attorney as soon as that happens as well?
Sure.
Okay. And I'm looking at the plea transcript from the day that the plea was taken, and the details of the plea. There's mention of the state's recommendation being 5 years with 2 years to serve for the various burglary counts. Does that sound accurate to you from that plea transcript?
Yes.
There was some testimony about surveillance video footage. Do you remember anything about that from these commercial burglaries?
Do I remember anything specifically about that? No, I mean, I don't. I just I have the report in front of me now, but I haven't, had a chance.
I understand. That's not a problem, Judge. Those are all the questions I have for Ms. Bagwell.
All right, Mr. Margolis.
Thank you, Judge. Good morning, Ms. Bagwell. Can you hear me okay?
I can hear you.
Hi. What is your typical involvement in the drug court admission process from your position as the assistant district attorney?
Well, we have a specific assistant district attorney that's the designated drug court attorney. So our office as a whole has a policy of flagging cases that are appropriate for drug court at the first appearance level. So the morning, like we get all the new arrests, we get a list of those, and then we have someone in the office that gives the announcements to the magistrate court on bond. So the announcement is either, a bond for whatever offense, no bond for some offenses. And then if it's somebody that meets the drug court criteria, then we would ask the magistrate court to hold them for drug court, and then the next Friday they would go in front of the drug court judge to either accept drug court or not accept it, or and the drug court team would then make the decision if they're a good candidate.
Okay, now but you said you don't do that yourself, right? There's another attorney in the office that handles that.
Well, we take turns with the first appearances. Sometimes I have done those occasionally when somebody needs someone to fill in or whatever, but the drug court attorney is not myself. No.
Right. Okay. So sometimes you're saying sometimes your office will flag a defendant for drug court.
Right. But now to be eligible for drug court, you have to live here in Hall County. And in Mr. Webb's case, he wouldn't have qualified due to that and due to his history and the gun charge.
Okay. All right. Just a minute, please. I'm sorry. Okay, so yeah, I've been over the transcript for this plea hearing, and I've participated in many plea colloquies myself. Was this particular plea hearing more disorganized than a common plea hearing in this court?
Only in that normally I would state the offer on the record to the court. That's the only thing that would have been that for some reason the court maybe got ahead of himself. It was most of those duty days are, there's like 30 cases on the calendar for an afternoon. So that's the only thing that was different. Normally I would state the recommendation on the record, and then but the judge had the recommendation in front of him.
Okay. And there are a couple points on the transcript where people are looking for papers, or the court doesn't have the case in front of them. Did you recall, that type of thing happening during this plea hearing?
Not off the top of my head. Sometimes he's finishing up one set of paperwork, and then he needs the signed accusation or indictment and the plea petition. And then if there's a Fourth Amendment waiver, he needs that. And I always just, out of abundance of caution, hand up the plea offer. It's like a little form with boxes checked and things like that. So
okay. But so just then, relative to, I guess, a non-duty day, the duty days are a little more chaotic.
A little more, but I mean, usually when we close out cases, we're closing out multiple cases, whether it's a duty day or if it's in front of the original Superior Court judge.
Okay. And this, you said there was a document, a plea recommendation document that was handed up to the court, right?
Right.
Is that something that would have been signed by Mr. Duttweiler?
No, it's a plea offer from me. So, I mean, I'm happy to screen share it if you want to see it. It's just like a grid with boxes checked. It's got Mr. Duttweiler. It's like a letter, but it's like a hybrid of a letter and a grid type form.
Okay, but it's not shown, or it's not signed by the defense attorney.
No, it's not.
And it's not signed by the defendant either.
No.
Okay. I have no further questions.
All right, thank you. Can Ms. Bagwell be excused at this time?
I just had one follow-up, if I may, for Ms.
Okay.
Bagwell.
Sure.
And this is just, Ms. Bagwell, I'm trying to clarify a little confusion that I have. I'm looking at the plea transcript directly here on my other screen, and this is you speaking on page 6, line 7. It says the state's recommendation is 5 years with 2 years to serve.
Okay, then I did say it. Okay, I couldn't find it when I was looking through the transcript.
Okay. And like I said, that's right there on page 6, line 7. So I'm confused about the representation of what the plea transcript says. Obviously, it'll speak for itself. I have no further questions for Ms. Bagwell.
All right, can she be excused at this time?
Yes, Your Honor.
All
Yes,
right,
Judge.
thank you. You are excused.
Thank you.
All right, Mr. Malcolm, do you have any documents to offer?
I do, Your Honor. I have them previously labeled as respondents 1 and 2. Just I did it that way because of the 2 case numbers. Would you like me to share my screen, or I'm not sure how Your Honor would prefer me to offer that?
You can identify, share them on the screen if you like.
Okay. Let me just try to do that, Judge. This is going to be respondents 1. Here we go. Can everyone see that? This is respondents 1. It includes the indictment. This is the possession of a firearm by convicted felon charge. It includes the waiver of rights form in that case, the sentence. I'm just scrolling quickly as well. At the end here, if I can get to it, the plea transcript. That is respondents 1. I would offer that into evidence, Your Honor.
Any objection?
No objection.
All right, respondents 1 is admitted without objection.
And next and final, Your Honor, is respondents 2, same documents except for that next respective plea case number there in Hall County. This is for the main charges, the numerous burglaries and theft. This is the indictment, plea, and sentence. The plea transcript as it was received from the clerk's office there in Hall County is attached. It's attached to R2 as well. I would just like to say for the record, there are a few highlighted things here on the copy I'm sharing with everyone on my screen. Those were highlights I made. They do not appear in the original documents and will not appear in the exhibits as I formally offer them to the court. But I would offer respondents 2 into evidence, Your Honor.
No objection.
All right, respondents 2 is also admitted without objection. Anything else, Mr. Malcolm?
No, Your Honor. Thank you.
All right, so gentlemen, both sides closed.
Yes.
All right, then the evidentiary hearing is closed. Mr. Margolis, you mentioned that you wanted to make a few remarks. I do have the brief in support of your petition that's previously been filed, but I will give you the right to make some argument. You may proceed.
Thank you, Judge. I'm going to activate my screen share again to put on display a case. This is Smith versus Magnuson. I wish I could talk while doing the screen share, but I'll mess both of them up at the same time. So. Okay, I think I've got it pulled up here. This is Smith versus Magnuson. For the record, 297 Georgia 210.
Your Honor, I'm not seeing a case. I'm seeing some highlighted portions of a transcript.
But it just got
There it
corrected.
is.
Is this the case?
Yes, it's there.
Okay, there we go. I'm sorry. As I said, I'd mess at least. All right. So here it is. Smith versus Magnuson, 297 Georgia 210. Alternatively, 773 Southeast 2nd 205. This is a Georgia Supreme Court decision. It's published 2015. An appeal from by the warden from a habeas petition in which the petitioner, or formerly the defendant, was seeking to have his guilty plea deemed invalid and seeking a finding that counsel was ineffective. The habeas court granted that petition, warden appealed, and ultimately the Supreme Court of Georgia affirmed the decision of the habeas court. I'm going to scroll down here, Judge, to would be located at 297 Georgia 213. citing previous Georgia Supreme Court precedent. The court states that to establish a guilty plea is valid, the trial court must inform the defendant the terms of the negotiated plea. In this case, Judge, as is clear from the transcript, the trial court did not inform the defendant the terms of the negotiated plea. As acknowledged by the state, normally they would put everything fully on the record, but regardless, it is the trial court that must tell the defendant what the trial court intends to do in a negotiated plea arrangement. That did not happen here. In fact, let me pull up a transcript here. We've got right here the court, rather than stating what the sentence will be, the court asks the state to recite the recommendation, and then the state does not restate the recommendation. We have, some conditions of Fourth Amendment waiver, specimen admissibility, etc. But the court never follows the law. The court never tells this defendant on the record what the sentence will be. So we have, what I believe, a very clear violation right there of the defendant's rights to be informed what a sentence will be when entering a negotiated guilty plea. We also have some discrepancy in exactly what the negotiation was for to begin with. The state testified that the recommendation would be 5 years with 2 to serve. I've highlighted the state's remarks in blue on this transcript here, which I hope everybody can still see. This is the state's recommendation, 5 years 2 to serve. The state could not find their own recommendation on another case. And Mr. Duttweiler chimes in. He's in pink here. He says it's the same as the other ones, referring to the other case. And then he states 5 serve 1 is plenty. This indicates that the time of this hearing, the defense expectation was 1 year to serve. Again, as stated by the defense counsel, and as stated by the defense counsel, this would be the same for both cases. As for the restitution, Judge, well, so just, I guess, maybe quickly to summarize this, it seems apparent from the transcript that the defendant, that Nathan, he did not know he was agreeing to a 2-year sentence. Okay. As for restitution, at the beginning of the hearing, I'm on page 5 of this transcript. It's very beginning. The judge says, "I'm not looking at any restitution orders," and he asked the defense counsel, "Is it your understanding that restitution is part of the negotiation?" The defense counsel says, I've never seen such a thing. Mr. Duttweiler testified today that before this hearing, there was no restitution in play. It had not been discussed. It had not been negotiated. It had not been worked out. As Nathan testified today, he didn't know that there would be a restitution. If he knew that there would be several $1,000s in restitution, he would not have entered this plea. The court acknowledged that there was a lot of restitution in play. And Mr. Duttweiler, here it is. Mr. Duttweiler, speaking on restitution, please again in pink, I can't argue with the restitution amounts. Now, Georgia law very clearly provides for a process for determining restitution amounts. Maybe obviously, maybe not, but if I'm running a store and some property is damaged at my store, and I contact an attorney, maybe it's an attorney for the district attorney's office, and I say, okay, so my door was broken, and I want $2,000 to replace this door. Well, that doesn't mean that the replacement door actually costs $2,000. That's just what the aggrieved party is claiming. And Georgia law has a very clear-cut procedure in the statutes at OCGA 1714-7B for a hearing on restitution. Mr. Duttweiler apparently was unaware that he could that the defendant could avail himself of that statutory protection. Your Honor, frankly, I wasn't aware Mr. Duttweiler would be testifying today, but he said some things to me as a defense attorney that were quite startling. He told me he was asked about whether he prepared a defense for the case, and he said, no, we didn't prepare a defense for the case. He said that he didn't review any of the videos with Nathan, even though Nathan had disputed with him originally that it wasn't him. That Mr. Duttweiler also testified he didn't review all of the videos. He said he thinks maybe he watched 2 out of 3 of the videos. So he did not prepare to defend this case. Mr. Duttweiler met with Nathan 2 times over the course of 5 months. He met with Nathan only twice in jail. First meeting, he determined that Nathan was, in his words, nutty, apparently nutty enough to merit ITF recommendation rather than RSAT. So there's definitely some mental health concerns that just were not addressed in this case. We had a discussion with Mr. Duttweiler on health court and what mental health court and whether just to have the support he needed to attend mental health court or to participate in that program. He said there was no support, and yet both of Nathan's parents were present at the plea hearing. Nathan's parents were involved in at least speaking to Mr. Duttweiler, helping him with the defense. This isn't a situation where Nathan is just kind of out there abandoned with no support structure. So basically, Your Honor, what we have is a trial court that did not inform the defendant of what the sentence would be in violation of the law. And we have trial counsel who misrepresented to the defendant the availability of an integrated treatment facility. And actually on that, am I still sharing? Yes. Okay. I have one last case, Judge, that I want to highlight here. This is it. Johnson v. Roberts. For the record, it's 287 Georgia 112. Alternatively, 694 Southeast 2nd 661. This is Supreme Court of Georgia in 2010. This is a case in which this is an appeal from a habeas petition. The defendant in that case had entered a negotiated guilty plea on an armed robbery charge. His defendant's attorney had told the defendant that he would be eligible for parole after a certain amount of time. Here it is. Johnson's counsel stated that an armed robbery charge carries a mandatory minimum. After that, as far as I know, it's parolable. This was inaccurate. Armed robbery is not a parolable offense. As a result, the Supreme Court of Georgia, the habeas court erred in holding that the defendant was not misinformed by his trial counsel. And in fact, the Supreme Court found that the habeas court was clearly erroneous. Very similarly here, Judge, we have trial counsel who told this defendant that he would be going into an ITF, an integrated treatment facility program. He said Mr. Duttweiler testified that he didn't really know how he would be admitted. He thought that he would be evaluated within the county rather than being sent down to Jackson for classification. regardless of what Mr. Duttweiler actually did or did not know, it is uncontroverted that he told Mr. Webb that he would be going to ITF, and that on that basis, Mr. Webb entered this plea. That was an inaccurate statement by trial counsel, relied upon by Mr. Webb. Um, and so for that reason also, we have here a situation in which the defendant enters a plea not only without knowing what's going to happen, but on bad advice by his trial counsel. We're only asking, Judge, that Mr. Webb be permitted to withdraw his guilty plea at this point. We have to do this in a habeas proceeding because the term of court for Hall County ended. This plea was entered on September 30th, which was a Thursday. The term of court ended the very next day, that Friday. And so he was jurisdictionally precluded from filing motion to withdraw in Hall County, other than that very next day. And Mr. Duttweiler, clearly didn't do it at that point. So for these reasons, Your Honor, we ask that you find in favor of the petitioner.
All right, thank you, counsel. Mr. Malcolm, do you want to respond?
No, Your Honor. I'll rest on what's already been presented and the documents from Hall County that have been admitted into evidence.
All right, gentlemen, one last issue that causes me some concern. The judgment and sentence that's currently on file in Hall County is incorrect as far as the sentence is concerned. Now, we've heard testimony that the sentence will be corrected or amended. Mr. Malcolm, could you see that the corrected sentence is made a part of this record?
Yes, Your Honor. I will make sure that we follow up with Ms. Bagwell and Mr. Duttweiler. I think they understand at this point the importance of getting that done ASAP. Once we get that, we'll certainly send a copy to Your Honor, Mr. Margolis, and ask if the court would like for that to be a part of this record. I think that would be appropriate.
Well, I think it very much needs to be a part of the record in this case. Any objection from either side?
No, I don't have an objection.
And Judge,
All right, then I'm going to leave the record open just for that purpose, to supplement the record to get the corrected sentence. Otherwise, I consider the evidentiary hearing complete. Do all parties agree?
yes, Your Honor. Thank you.
Yes, Judge.
All right, have a good day. Thank you. The hearing is ended. We're going to take a break. Mr. Malcolm, Judge Carp, I'll be presiding for the rest of the morning here.
Okay, Judge. Good morning.
Good morning to you. I understand we have one case with a witness left, and that would be the Burnett case. Is that correct?
Yes, Your Honor. And that witness is Leah Abbasi, and I believe she is on the call currently.
I see her name. I don't see the other. I guess that must be. I'm looking for the petitioner, who I don't see. Mr. Burnett. Oh, there he is. I guess that's him. You, Mr. Burnett?
Yes, sir.
Mr. Burnett, Carp will be presiding over this habeas hearing this morning. Can you hear and understand me okay?
Yes, sir, I can.
And can you see the other participants on your screen there?
I see Clint Malcolm. I see yourself. I see Leo Abbasi. How you doing, Mr. Abbasi?
Hi, Mr. Burnett. It's nice to see you.
Nice to see you too.
All right, so Burnett, let me get you sworn in for this hearing, please. Would you raise your right hand, please? Where the evidence you're about to give in this hearing should be the truth, the whole truth, and nothing but so help you God.
I do.
And Mr. Abbasi, you're going to testify as a witness, so would you raise your right hand also? You swear the evidence you're about to give in this hearing should be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
And Mr. Malcolm, you want to call your witness out of turn, is that correct?
That's fine, Your Honor, so we can let Ms. Abbasi go about her day.
Okay, Mr. Burnett, we're going to call Ms. Abbasi first, even though it's a little out of turn, so that she doesn't have to be here for the rest of the hearing.
All right.
So Mr. Malcolm, you may proceed, Mr. Abbasi.
Thank you, Your Honor. Respondent would call Ms. Abbasi. She has been sworn already by the court. Ms. Abbasi, would you state your full name for the record, please?
My name is Leah Abbasi.
And how are you currently employed, ma'am?
I am currently in private practice.
Okay. As an attorney?
Yes.
How long have you been an attorney here in Georgia?
Almost 10 years.
Okay. Have you been in private practice that entire time?
No.
Could you briefly tell the court your occupational history as an attorney?
Yes, from the time that I finished law school, almost as soon as I passed the bar, I went to work at the Office of the Metro Conflict Defenders, which is like the public defender's office, but conflict in Fulton County. I was there until 2020, where I went to Clayton County Public Defender's Office for about 10 months, and then went back to the Fulton County Public Defender's Office until the beginning of February this year. So my entire career, except for the last 2 weeks-ish, has been as a public defender.
Okay. So safe to say, obviously, as a public defender, it's 100% criminal defense work during your time as a lawyer.
Yes.
And had you had the opportunity to represent Mr. Lipo Burnett, I believe, when you were working in Fulton County?
Yes.
Okay. And those were some charges of rape and aggravated assault. Does that sound correct to you?
Yes.
Okay. Prior to representing Mr. Burnett, had you handled or represented other individuals charged with similar crimes?
Yes.
And had you handled or had you represented defendants at felony jury trials prior to Mr. Burnett's case?
Yes.
About how many would you say?
Could you remind me what year was Mr. Burnett's case?
Mr. Burnett's case was 2018.
At least 15. I'm sorry, I don't know, definitely.
That's fine. That's the toughest question I'll ask. Just trying to get an account of your experience. Obviously, you worked for the Public Defender's Office for a long time. Guilty pleas, I'm assuming before Mr. Burnett's, you would handle numerous guilty pleas in various courts.
Yes.
And those included felony guilty pleas.
Yes.
Do you recall at what point in the proceedings you got involved in representing Mr. Burnett?
Yes, it was post indictment when he was assigned to the courtroom I was assigned to.
Okay. Is that pretty customary of how things worked there in Fulton County at the time?
Yes, with my office, yes.
Okay. So you would have started representing him, I'm assuming at his arraignment or around that time?
As soon as we got a calendar, that he was coming up in court, we'd get the calendar, go through, figure out if it wasn't already clear who the clients were. So generally we go see someone prior to arraignment.
And the original charges, as I understand them on the indictment, were what I already mentioned, as well as an aggravated sodomy and kidnapping that you ultimately were able to get null-prossed by the court as part of the plea.
Yes.
Do you recall the state's evidence or the facts of the case? And if so, could you give us a brief synopsis of that?
Yes. This case, I remember it quite well because we were about to start trial when the plea happened. There was a woman, I don't remember everyone's names first and last. Her name was Brandy. She was kind of stumbling down the street and flagged some people down, saying that she had been kidnapped, she had been raped. She believe gave a general description of who it was. She had actually taken the phone of this person. She had gotten into a vehicle with him, took his phone. They got out, they went into a house. She said that he clocked her in the head and then raped her. I don't remember whether the sodomy was oral or anal, I don't recall. And then he left and drove off. I believe they identified him by looking through the phone. He was later arrested. I don't know that they ever showed her a lineup. Mr. Burnett spoke to the police when he was arrested. A rape kit was done, and it had, I believe, the DNA of other people, not Mr. Burnett. During the course of the investigation, there were several witnesses who were identified. They were aunt and uncle. I don't remember if biologically or just close, of Mr. Burnett, who this woman Brandy had told that she was not raped. It was a transaction that had gone bad, and she lied because she had crack cocaine on her at the time. And that was actually true. That was in the medical records, nowhere at all in the police report. So I thought we had very strong evidence that indeed Brandy had told these folks it was not a rape, and that certainly was truthful to folks saying it. There was no possible way they could have known about the crack cocaine but for her giving that statement. I also spoke to her once at length. Certain parts of what had happened, the outcry was made to, I'm just going to make up a name because I don't remember it, or made to Rhonda. I said, do you know Rhonda? And she said, no, I've never heard of any person by that name. She'd said she didn't know the person who attacked her. However, there was a history of Mr. Burnett had sold drugs in the area. He had sold drugs specifically to her. He knew her, and there were other witnesses who had seen them together and said, yes, they know each other. And we were prepared to call that witness at trial, subject to we needed a material witness warrant because he had said he was not going to come. I'll probably remember other little things, but that is the gist of it. She said the person who she took the phone from did it. She said it was an accident. She took the phone. We believed otherwise.
Okay. So it sounds like that the trial was imminent in the case, and you had taken active steps to investigate potential avenues of defense for Mr. Burnett. Does that sound right?
Yes. Yes. The aunt and uncle, I had been to the home where I guess they lived later. It wasn't where they lived at the time. I went and I spoke with them. I went to the scene of the alleged incident several times. The house, I believe, was demolished by the time I was there. But we went through the neighborhood, did speak to some other people to see who knew Mr. Burnett. He'd given us some witnesses who we spoke with, all of those that we could find. And I did speak with the alleged victim herself before trial.
Okay. And as we've discussed, you said trial was imminent. How did this case ultimately resolve for a guilty plea? Could you describe that process for us?
Yes. At the time, well, I don't know. At the time, it was constantly changing who the prosecutors were in the Fulton County district attorney's office. I believe this case had at least 5 different prosecutors. Going into the trial, Mr. Burnett was always at least open to a plea, not because he admitted any of this had actually happened with her, but Mr. Burnett's defense was in part, I'm not a rapist, I'm a drug dealer, which is not the most ideal defense to put up in front of a jury. So we were always open to a plea. I had attempted to discuss that with multiple different prosecutors. Maybe about a week before, I don't know if it was even a week before the trial. We got a new prosecutor, spoke with him. He thought maybe we could work something out on an aggravated assault to 6 years. Got there the morning for trial thinking, okay, we'll go forward from that. He hadn't gotten approval from the supervisor. Judge was highly upset because even the morning of trial, we did not have an offer from the state, and she knew we had been asking for one since day one. She demanded the supervisor come down to the courtroom, and at that point, she gave the offer. I asked if I could have more time with Mr. Burnett than 15 minutes before we started trial, because we had come into that day thinking we might be pleading to 3 years and then got an offer of significantly more time. But she would not allow that. Mr. Burnett had to decide right then.
Okay. So other than the short time as you described as 15 minutes or so, were you able to communicate the state's offer to Mr. Burnett that day?
Yes,
And did he understand the state's offer?
he did.
And did he ultimately agree to accept it?
He did.
And was that the offer that was ultimately the sentence that was entered, the 10 years to the lesser included provision under the rape statute OCGA 17-10-6.1 subsection E that allows the court to deviate from that mandatory sentence which is typical for rapes?
Yes.
And also, I believe that negotiation involved an all process or dismissal of the aggravated sodomy and kidnapping.
Yes.
Okay, so the only other remaining charge was the aggravated assault, and he didn't receive any additional prison time on that. Does that sound correct?
That sounds right.
Okay. Prior to the plea, did you go over with Mr. Burnett the rights he'd be waiving by pleading guilty to the state's negotiation?
Yes.
Okay. I'm assuming that included the right to a jury trial, right to confront witnesses at that trial, and his privilege against self-incrimination.
Yes, and I don't specifically remember doing it, but that courtroom, we always did a plea sheet. So it would have been done with Mr. Burnett. I don't have an independent recollection of it, but that judge never accepted pleas without a plea sheet completely filled out.
Do you have any recollection of Mr. Burnett equivocating or indicating to you during the plea or after the plea that he had wanted to change his mind?
I don't think so. I remember at least ahead of time, it was a really, really difficult decision. I honestly don't remember
Okay.
his demeanor afterwards.
Mr. Burnett's raised the ineffectiveness claim specifically concerning the indictment. Did you review the indictment in Mr. Burnett's case?
Yes.
Did you see any basis to challenge it through a demurrer or any other available means?
No.
Your Honor, those are all the questions I have at this time for Ms. Abbasi.
All right, Mr. Burnett, would you like to ask her any questions?
In fact, I do.
All right.
How are you, Mr. Boston?
I'm fine, Mr. Burnett. How are you?
I'm here. Okay, I have a couple questions. Mr. Vassie, is it true that a jury trial can find me or any person guilty without sufficient evidence in the state of Georgia?
You're a little muffled. I believe you said, is it true that no jury can find you guilty without sufficient evidence? Yes, that is true. A jury must find you proven guilty beyond a reasonable doubt.
But it's true that they can find you guilty without sufficient evidence, right? They don't have
Your
to
Honor,
pay attention to
objection.
them.
I don't see objection, relevance, and cause for speculation.
Mr. Burnett, you can have more specific. You're asking a general question. And
We'll move on.
doesn't seem to be relevant to the case.
Yes, Your Honor, we'll move on. Okay, so how often did you receive letters concerning Mr. Burnett's discovery and the inconsistencies that were very noticeable showing in the discovery?
How often? I couldn't tell you how often. Since I left that office, I don't have access to the file, so I don't have physically all the letters in front of me. I recall you did write a lot of letters which were very specific and did contain good points. I couldn't tell you how many, but there were quite a few.
Don't worry, I'll show you. Okay, what was your response when you got those letters, Mr. Boston?
To them, I believe I would either write back or come and speak with you. I tried to make sure to address them in some way, shape, or form. I'm sure I told you, as I do with all of my clients, the best way to contact me is by letter. That way I can make sure I'm able to address all the things that you're bringing up.
Okay. Okay, well, with the inconsistencies, do you remember if there were any time that you let the DA know? Or did you contact any higher authority above your pay grade to let them know that, hey, this investigation was done incorrectly?
Yes.
You did? What was said?
I recall discussing with them, this was a very poor investigation, that their victim simply was not credible. After I had went and spoken with her, and she was saying all sorts of things contradictory to what was in the police report, I remember saying, you know, this woman is nuts. I can't believe you guys are going to try this case. I did not want to tip our hand and specifically tell them about the point where the aunt knew about the crack cocaine she had, because I wanted obviously to save that for trial. But I know I did talk to the prosecutor a number of times, including, of course, the supervisor, that this was a case I didn't think should have been lined up for trial.
Okay. Did you know that DNA did not match with me or?
Yes, I recall that.
You recall that? Okay.
Yes.
I have exhibit. This is the GBI, Division of Forensic Sciences, Georgia Bureau of Investigation, State of Georgia. Headquarters got the DOFS case number report. It got all the works on it to show that this is official. Agency reference number requested. Okay, so anyway, it has my DNA that says that it went into CODIS and it came back. It did not come back inside the matter, the case. It did not match with
Correct.
me, right? Correct. Okay.
Correct.
Get that on record. Do you guys have the same sheet? This is the Georgia Bureau of Investigation Forensic Sciences. Okay. So after you found out the DNA didn't match, did you let the DA know or the higher authority?
I mean, they provided the report to me, so they already knew. I'm sure it was something we discussed when I discussed with them. I thought this was a poor case.
Have you seen them take action if they can see the mess up or they can see the discrepancy or the inconsistency? Wouldn't they take action usually in a better direction so that they don't waste any time? Because it seems more like
Objection, speculation, cause for speculation.
Sustained. What might have happened is not a proper question.
okay. Okay. Do you remember going to court, Mr. Bossy, and saying that you were missing a piece of the discovery?
I'm not sure. I think you'd have to be more specific.
Okay.
I remember they were being really obnoxious about getting me the file. I kept asking for it and not getting it. And finally I subpoenaed the officer and made him come to court and bring it. And I remember the judge kind of gave him a look and said, you know, you need to be more on this as far as getting me the entire file. I don't know if that's specifically what you're referring to, but I mean, they were not especially forthcoming and helpful with providing discovery in this case.
Okay, well, this document is very important to me. This document actually shows that this is the document that we went to court a little bit after my birthday. Okay, so this document is the document said that we weren't going to proceed with the case any further until you put in the order to come back to court for a document that I was confused about. I didn't know what we were talking about. Maybe like 7 days later, we came back to court. I didn't see a judge. You came back, you had to fold it up like this, and you said, I'm not proceeding. I told you I wasn't proceeding, so I got the document that I needed that's missing out of the discovery. This document is an Atlanta Police Department case management report, page 9 of this page 9 of the discovery. It's very important. So what this document shows, Mr. Bassi, is that once we're obtaining.
Your Honor, I'm trying to give Mr. Burnett some latitude, but I believe at this point he's testifying. He needs to ask the witness questions.
Yeah, Mr. Burnett, get to the point here. Just
Okay, I'll get to the point. Okay, you put in the motion for us to come back to court 7 days later to get this document. This document is case 9. This is case management report, page number 9. Actually,
what's the
out of
question?
the discovery.
What's the question?
This document shows that the case was turned in to the DA without a photo lineup. After you found that out, Mr. Bassi, what kind of action did you take after the DA called the DA called Detective Schlussbeck for a photo lineup with this case file? What did you what was your action after that, Mr. Bassi?
I'm sorry, I'm not sure where in the timeline of the case we are. Can't specifically tell you when I got that page. I'm sorry, I don't remember.
Well, I had just been, I had just received the discovery maybe a month and a half ago at that point. And you claimed that we were missing the document. You got the document for me. After the document had been removed from the discovery, you filed a motion to get the document, which is this. So after I got the document, I'm asking what action was taken to, because this actually it shows that the DA, he turned the case into the DA without a photo lineup. I'm asking, after I pointed that out to you, or after we received the document, what kind of action did you take towards the lineup not being conducted?
I'm not sure I did anything specific as far as the lineup not being conducted. I really don't remember. I'm sorry.
Okay, is that Mr. Boston, with all your training and all your tenure experience, wouldn't you say that the lineup would be pretty important to the investigation, right?
Yes.
Okay. Okay, did Detective Sluss actually tell you that a photo lineup had not been conducted during the investigation?
I believe he confirmed that he had not done a photo lineup.
Okay.
Pretty sure on that. I remember having a conversation with him outside the courtroom when I was trying to get the discovery, and I was specifically asking him, where's this, where's this, where's this, where's this? And I think he said that was one of the things he had not done. It was not that we were missing it, he just hadn't done it.
Okay. Thank you, Mr. Mozzie. Is the investigation is a part of obtaining the warrant, right?
Wait, hold on. Now you just went. I can't hear anything now.
You can't hear me? Can you hear me now?
Now I can. Yes, I don't know what you.
Okay. So during the investigation, photo lineup is important, right, Ms. Fossey?
Yes.
Okay. I just want to have that. I want to get the clearance on that. Okay. So did Mr. Burnett contact you about those things, dealing with the 6-man lineup and so on?
I don't specifically recall a specific letter or conversation, but I'm quite sure you did. You were very thorough in looking through the discovery and pointing out discrepancies.
Okay. Okay, so, okay. Moving on, moving on. We can move on past those things. Is it? Okay, so, okay, we would agree that, proper procedure, would take effect in the investigation, right?
I'm
When you
sorry.
take proper, okay, isn't this the right procedural activity to take in the order of obtaining a warrant, Mr. Bison? Like,
I'm sorry, I don't understand the question.
okay, within the investigation, uh, if you're gonna obtain a warrant, you would want to follow order, right?
Okay, I think I understand your question. Yes, I certainly think they should have done a photo lineup before going and taking out a warrant.
Okay. Uh, did you believe Mr. Burnett's innocence?
Yes.
How many times did Miss Jackson contradict herself or make a lie up during the interview that you had with her?
I could not even begin to tell you. Way too many for me to keep track of.
Okay. Um, okay. I remember you said that you just used the name earlier when you were talking to Mr. Malcolm, but I remember this is the sheet that I received after the interview with Miss Jackson. And she claimed that she denied knowing anyone named Joanne.
Joanne, yes, that was the name. I couldn't recall the name, but yes, I remember her saying that. When I spoke to her, she had no idea who Joanne was. She didn't know a Joanne.
Okay, so this sheet right here, Mr. Bosley, is very helpful because to me,
Your Honor, I'm going to object. He's reading from a sheet that's not in evidence. That's
this is in
that's not in
evidence.
evidence.
This isn't in evidence, Mr. Bosley.
I
I
can't
don't know
see
what you
it.
have in your hand.
Apparently not. But
This,
Mr. Burnett.
okay, my point
Let me
is,
stop you- let me stop you for a minute. All these questions that you're asking relate to the police investigation. Am I right? What they did and didn't do?
yes, sir, it's all gonna come together. But if you want me to get straight to the point, I can get straight to the point if you
I'd
would
like
like.
to get straight to the point, yes.
Okay, straight to the point would be this. The Constitution the Constitution states that due process and order has to be, well, due process and order has to be taken with anything. I would agree on that. Okay, so with order, without taking the point.
Stop. I want you to ask Ms. Abbasi whatever questions you want to ask her that relate to the point. You will get a
Okay,
chance to argue your case in a minute, okay?
do you think my rights have been violated, Mr. Bison?
I'm not really sure what rights you're referring to.
Well, earlier you stated that we would have to, okay, to obtain a warrant, you would want to follow the steps of proper order. And proper order would be a 6-man line, 4 to 5 to 6-man lineup or a live lineup. So if those things had not been obtained, then how did we get a warrant?
I did not think that you should have been prosecuted under these facts. I don't know if that answers your questions. I did not think that they had sufficient evidence or that it was really appropriate to be prosecuting your case, given the facts that came to light during the case.
Okay. I think that you answered that question to the best of your ability. Thank you. Okay, so why do you think that Discovery was missing this sheet? I'd like to ask.
Because they were lazy and they didn't really care. I had that experience constantly with Fulton County. We just kind of get a file and there might not be anything there or everything there because no one had looked at it because the case was constantly changing between prosecutors every month or so. I don't think anyone had actually bothered to look at it.
Okay. Can you tell me why the case was not thrown out?
Nope. Not a legitimate reason,
Okay.
except that
Well,
just they generally had a policy of just, if it was charged, they were going to go with it. It's very, very difficult to get cases null pros, even when it was abundantly clear that they should be.
Okay. Well, I can get into a lot of things, like, did Ms. Jackson state that she didn't recall any tattoos? But again, that would be the investigation. So I'm here today to show you that the Constitution has been violated. Mr. Bossi,
Hold on. Do you have any other questions for Mr. Bossi?
I just excused Mr. Bossi, Judge Rose.
I'm Judge Carp, not Judge Rose, but regardless.
Oh.
You have no-
Well, that's the name that's up there. I apologize.
I know, we hadn't fixed that yet.
Okay, I apologize.
You have no other questions for her?
Mr. Bossi, thank you.
You're welcome, Mr. Burnett.
Mr. Malcolm, any other questions for Mr. Bossi?
Just a couple follow-up, if I may, Your Honor. Ms. Abbasi, you testified earlier that you, the trial was imminent. I'm assuming you were prepared to try Mr. Burnett's case if it had come to that. Is that true?
Yes, the one hitch to that is the judge still had not signed the material witness warrant for our witness, Tim. That was one reason the judge was really angry and demanded the supervisor come down, because I was asking somebody be arrested and locked up until trial. She wanted to make sure this was a trial which was actually going to happen before she did that. So subject to having that witness, it was ready.
Okay. So you were ready, subject to that issue, you were ready to proceed to defend Mr. Burnett to the best of your ability at trial if it had come to that.
Yes.
And all the potential issues you discussed through your testimony that you perceived about the case, you certainly discussed those with Mr. Burnett in regards to the state's evidence and how y'all would challenge that if the case went to trial.
Yes.
Okay. And despite that, you also have a duty to convey any plea offers made by the state to your client.
Yes.
So you did in fact convey the plea offer to Mr. Burnett, and he ultimately accepted the plea offer made by the state.
Yes.
That's all I have, Judge. Thank you.
Judge, if I may ask one more question.
Yes, you may.
Do you remember this sheet, Mr. Bossi?
I'm not sure.
Okay. Well, this is part of the discovery. This shows where 14th Amendment has been violated, where due process has been corners have been cut to get obtain the warrant. And this is you provided me with this. This comes from the discovery.
Judge, he's arguing with the witness. He's not asking her questions.
Is that a question?
I'm not arguing with the witness, sir. I'm informing her. I'm informing her.
No, ask her whatever question you want to ask her.
I asked her, did she remember this particular sheet? Because I got it from her.
And I think she said no.
Oh, I don't remember that particular sheet. I do remember in the file, there was I believe it was a 6-pack. I'm not sure if that's what you're holding in your hand, which is why I kept asking, where is the lineup which was performed in this case? And it took the detective to come to court and say, I didn't do one, because it was confusing that why was there a lineup photo if one was not performed.
Okay, if you give me time to get straight to the point, because okay, I just wanted to show you this. You provided me with this. I want to ask you, is anyone circled?
No.
I got this from you. Thank you. Thank you, Mr. Bossi.
All right,
No
anything else?
further questions.
No, nothing from
No further
respondent.
questions.
All right, Ms. Abbasi, you may be excused. Thank you for being here.
Thank you, Judge.
All right, having taken the witness out of turn, we'll go back to the top. And Mr. Burnett, you can now put up whatever evidence or argument you'd like to make in your case.
Well, Judge, when you get down to the nitty gritty of everything, the 6-man photo had not been conducted, Your Honor. And I think that we just heard the attorney herself say that she fought with all she had. She did fight with all she had until it seemed like someone told her to stop. I have numerous inconsistencies, Your Honor, to show that my innocence, to show my only mistake was selling drugs, sir. I was
I'm
accused
sorry.
of something.
Stop. I couldn't understand the last thing you said.
I might have hit the end. My only mistake, my only mistake, sir.
Go ahead. Go ahead.
My only mistake might have been selling drugs, sir. Because it's wrong. Okay, doing wrong things lead up to other wrong things. I guess lies get told. Word of mouth can get you arrested in the state of Georgia, and you have to sit until otherwise. Your Honor, I have the sheet that shows that 14th Amendment. I think that I was deprived of liberty because of if you don't get a photo line, if you don't follow order, without order, there's chaos. If you don't follow order, then then everything just goes everywhere. So then you can do anything. So if no one circled this for you to obtain the warrant, who is the case on, sir? And so it's so many things that show that corners have been cut, and there's a sheet that says CODIS, and DNA goes into the machine, and the machine, and okay, so it spits out the name. This came back and said that the octane, it was unreadable or anything, something like that. Sir, I'd like to be granted relief for the simple fact that it's so many things that show that I was convicted of a lie, and that she stated in the beginning, Your Honor, that my first question to Mr. Bossi was, is it true that a jury can find me or any person guilty without sufficient evidence? She told me that. That's why I asked her that. So if she told me that, that means that I could look like I did that, or I could smirk, or I could frown, or I could cough wrong. And it could be two jurors to say, hey, I don't like him. So then I have to do a life sentence. I'm not gonna say it's not fair. Because maybe you shouldn't have had yourself in a situation to have a situation. So this is my only way out of the situation, to show my innocence through you all and the documents that were provided by the system.
Okay.
And so here I am, and I have them. And what I was accused of was only maybe selling a rock, sir. But what I'm wrong of is selling a rock, sir. What I'm accused of, sir, I did not do. And so it shows, and I'm grateful for the opportunity of the habeas corpus to be able to show it, to present it, because I told Mr. Bossi so many different times that, well, this and that and this and that, and she say, don't talk over the phone, or she say, she ignored me, or she brushed me off, or you know what I'm saying, and it's like you can't get any help. But I have the documents here. You know, but we're fighting. We're only fighting. I'm only challenging the 14th Amendment and the deprivation of my liberty, my freedom. So I'm not gonna get into the specifics of the case, even though they show I have over 20 inconsistencies and corners cut. You know, and ain't no telling who else back here. They got the same thing going on. But I can show mine. And so by me showing it, I just feel like, Your Honor, that I maybe did $120,000 worth of paralegal work myself, because I felt like my life was important enough. I don't know how many people take their life serious. I'm in a level 5, maximum security, and the death toll is very high. I think that I should be granted relief because I care about myself enough to fight me. And it's without a doubt that the 14th Amendment was violated, if we're going to talk about due process and the steps that are taken to obtain work correctly and to uphold justice, would only be to grant me relief, sir.
All right. Mr. Malcolm, any questions?
Just one or two, Mr. Burnett. Mr. Burnett, you referenced this photo lineup that you've showed us, and also the GBI DNA test results, and Ms. Abbasi testified about that. You received those documents from Ms. Abbasi, you said, correct?
Yes, sir. I received those. I received those in the discovery. She's supposed to have received the discovery first, and it came in the mail. So it came from the public defender's office.
But you had those documents as part of your discovery and knew about them when you pled guilty, correct?
Yes, sir.
That's all I have. Thank you, Judge. Thank you, Mr. Burnett.
All right, Mr. Malcolm, it's yours out of the case.
Judge, all I have two documents, Respondents Exhibit 1 and 2. I'll share my screen so everyone can see what I'm talking about. Respondents 1, Your Honor, and Mr. Burnett, this includes the plea sheet as well as the indictment and sentence from Fulton County in Mr. Burnett's case. Obviously obtained this from Fulton County. We'd move to admit Respondents 1 into evidence, Your Honor.
All right, it's admitted.
And Respondents 2, Your Honor, is the guilty plea transcript there from Fulton County, December 10th, 2018. We move to admit that into evidence as well.
Okay, that's admitted also.
Thank you, Your Honor. That's all I have at this time.
All right, Mr. Burnett, anything else?
If you all have copies of these things in the discovery, if I wanted to submit these exhibits, would I give them to Ms. Michael, or what? How would I?
Well, if you want me to hold the record open for you to submit the, I guess that's the lineup photo page and the DNA exam. Is that what you're asking to do?
You got page 9 of the case management plan from the discovery, and you have the photo lineup, and then you have the DNA.
Any objection, Mr. Malcolm?
Well, Your Honor, if I recall, I believe he asked Ms. Abbasi about those documents. I think it was established she had them in discovery. I have no objection to them being admitted for the limited purpose to show she had them at the time of her representation of Mr. Burnett.
Okay, Mr. Burnett, I'll hold the record open. You can submit them to the clerk to be included in the record, and I will, we'll add them to the record. Okay?
Okay. Yes, sir.
Do it quickly, though. I'll give you 15 days to get it added to the record.
To add it to the record, yes, sir.
You just mail them to the clerk, reference the case number, and ask that they be added to the record.
Yes, sir.
Okay. All right, otherwise, the hearing is concluded. I'll take the matter under advisement and review the evidence and issue an order. All right, Mr. Burnett can be excused.
Thank you.
All right, we have one other case. Which one is it?
Richard Lynn, Your Honor.
All right. Mr. Lynn? Where's Mr. Lynn?
I believe Mr. Lynn should be there at Smith State Prison where Mr. Burnett was.
I'm sure he'll be around in a second.
Okay.
Are you Richard Lynn?
Yes.
Mr. Lynn, I'm Judge Cole. Mr.
Long,
Lynn,
can I just leave it like this? Sir?
Mr. Lynn, can you hear me okay?
Yes, sir.
And can you see the participants in this hearing on the screen?
Yes, sir.
Mr. Lynn, I'm Judge Carp. I'll be presiding over this hearing today. You filed this habeas corpus petition. Is that correct?
Yes.
And you ready to proceed today?
Yes, sir.
Mr. Lynn, do you intend to testify in this hearing or simply argue? You can do both, either or both.
Could you repeat that question?
I'm asking whether you intend to testify during this hearing, or are you simply going to argue your case, or both?
Oh, just to, argue.
Just argue.
Yes.
That means you're not going to testify. So, yeah, you argue your legal points. That's what you intend to do.
Well, the things that I had wanted to, testify to, I submitted them in affidavits to the court as exhibits.
I'm not sure that's going to be sufficient. You might need to be sworn and testify to those things. And you're subject to being cross-examined by the Attorney General. You understand that?
Yes.
And so why don't you raise your right hand and be sworn? Swear the evidence you're about to give in this hearing should be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, Mr. Lynn, then you may begin.
Okay, I wanted to, do, a quick recap on the incidents that led to my arrest. Is that okay?
Yes, but be brief, because you need to get to the point.
Okay. Okay, on March 10, 2015, Roswell Police Department Investigation Section came to the Atlanta hotel to conduct a drug investigation based on high level of known drug activity in the area. There was no prearranged drug transaction or intended target. The Roswell detectives used a confidential source to make random attempts upon the hotel property to purchase heroin. The CS was eventually led to a female whom escorted the CS to room 243. There, the female entered the room alone and came back out seconds later and provided the CS with heroin. The next day, March 11th, the detectives installed a video surveillance in the area of the Atlanta hotel facing room 243. Through this surveillance, detectives observed me entering and exiting room 243. On March 12th, while conducting physical surveillance of room 243, detectives observed me leave room 243, get into a car, and drive next door to the parking lot of another hotel and made contact with a man named Michael Dorsey. When detectives ran the license plate on the car I was driving, the car registration came back as canceled. Based on this, once I got back into the car and drove back onto the public roadway, I was stopped by police. After a check of my identification, officers found that I had a warrant for probation violation. It was at this time I was arrested. During my arrest, officers approached and questioned Dorsey, at which point officers found that Dorsey had been trespassing at the Atlanta hotel this same day. For this, Dorsey was arrested. At the Roswell Detention Center, Dorsey was interviewed and advised by detectives that if he provided information regarding their investigation, he would be released from custody. Whereupon Dorsey told detectives that he had recently purchased drugs from me in room
I'm going to
243.
object the hearsay to what Mr. Dorsey said, Your Honor.
Yeah, and Mr. Lynn, you need to get to the point. I mean,
I mean, this just the evidence that I'm laying out, the evidence that was introduced in trial.
Your Honor, may I respond to that?
yes.
Mr. Lynn has filed a lot of claims that we've asserted a res judicata that they were decided adversely to him on appeal, including a sufficiency of the evidence claim that was raised on his behalf through counsel on direct appeal, and the Court of Appeals found the evidence was sufficient for a jury to convict. So I'm not sure the relevance of the sufficiency of the evidence at this point.
Mr. Lynn, we're not here to retry your case today. That's not the point of this habeas hearing. I mean, I'm not going to, what you say and come to some conclusion that you shouldn't have been convicted because I don't believe the evidence. That's not my role here. You need to point out some errors that are addressable by habeas corpus that I can consider that might cause conviction to be reversed, but not because the evidence is lacking. That's not the issue here. I mean, I'm gathering it appeared to be a drug deal and you got arrested for it. What it sounds like.
Well, young, that's what I thought the insufficiency of the evidence. Is that not an issue?
No, if it's going up on appeal and the Court of Appeals found that the evidence was sufficient, then I can't overturn that.
Okay, well, the other issue I was going to raise is that there was evidence that was introduced that was illegal.
And was that raised on appeal also?
Yes.
And the Court of Appeals found that the evidence was legal?
Well, as far as what I was claiming was that the evidence of uncharged crimes, they were saying that I sold drugs. There was witnesses who testified that I sold them drugs. The state introduced a bench brief in which they said that they was attempting to submit this evidence under the ground that it was intrinsic because it provided motive. However, the evidence was not intrinsic. And so upon that, I was saying that it was illegal evidence and it violated my Fifth Amendment, the Fifth Amendment, because there was not only an indictment or presentment.
Okay, what else?
And so what I was trying to show is that if you remove the testimony of the uncharged crimes being the drug transactions, then the rest of the evidence would establish no more than my presence on the crime scene, which is insufficient to support a conviction.
Your Honor, if I may, for the record, the issues on appeal also, other than sufficiency, included a challenge to a search warrant at the hotel room, as well as to a challenge to the admission of prior act evidence. Those were decided adversely to Mr. Lynn. So my understanding, if he wants to try to get around that procedural bar, he's got to tell us something that's changed in the law or the facts of his case, and not just recite the same arguments that were made on his behalf on appeal.
Well, Your Honor, the thing is that this was never, although the court, the state never submitted an argument in front of the court. The state just basically said that they presented a bench brief. I objected, saying that that it wasn't that the testimony that they was looking to submit, it wasn't intrinsic to the charged crime. The Court of Appeals, they basically they did not. If you look at the Court of Appeals ruling, they do not say whether or not the evidence was intrinsic or not. Matter of fact, they're basically saying that it's intrinsic and it's other evidence. They're basically saying that there's a hybrid. They never say that, they never go each way. I mean, you can't say that the evidence is intrinsic and other evidence. When the state submitted the evidence as intrinsic because it provided motive.
And the Court of Appeals consider those arguments? Mr. Lynn?
Yes, it is. But the point that I'm getting at, Your Honor, is that the Court of Appeals they don't reach a conclusion. If you look at the Court of Appeals ruling on the issue of intrinsic evidence, they do not reach a conclusion based on law.
Okay. What else you got?
Well, yeah, I had just want to go over how the evidence wasn't intrinsic to the charged crime. Okay, so
And Your Honor, before Mr. Lynn goes into that, without knowing what he's going to say, that the Court of Appeals addressed this issue. I'm not trying to belabor the point, but my objection would be relevance. I suppose that if he's trying to tell us something that's new or different, then obviously that would be relevant, but I'm not hearing anything of that. I'm looking right at the Court of Appeals decision where it's talking about the prior act's evidence.
yes, again, Your Honor, if the Court of Appeals is not going by prescribed law that has been established for the Court of Appeal when assessing other act evidence or intrinsic evidence, then that is the degree of deviation from the prescribed law is raises to the point of due process violation. And I would ask the court to look at the Court of Appeals ruling dealing with the uncharged crimes. Look at the ruling and look at the prescribed law that the Court of Appeals is supposed to apply to that, and see the degree of deviation from the law.
So you're asking me to overrule the Court of Appeals?
Sir,
You're asking me to overrule the Court of Appeals?
I'm not asking you to overrule. I'm asking you to see that I haven't been given due process of law. If you look at the prescribed law and then look at how they deviated from it and the degree of the deviation from it, then I think that rises to the level, especially under how the substantial it would be for me to be charged with one crime and then have evidence of other crimes. I'm being charged with being in possession of drugs, but here I have 3 people come to my trial and say that he sold me drugs. That is a substantial that is a substantial prejudice.
Okay.
I would think that it'd be to overrule the Court of Appeals, but just to say that the Court of Appeals did not go by the law that the Court of Appeals is supposed to go by.
All right, what else, Lynn?
Okay, I just wanted to read this right quick. Got something I wanted to read. Okay, so I did not receive a fair trial due to state witnesses Lambert, Welch, and Dorsey testimony which described the uncharged crimes of my participation in prostitution and drug distribution, none of which derived from or was intrinsic to the circumstances or events of the charged crime. Okay, the acts described in the state witnesses' testimony do not meet either of the 3 requirements as laid out in Smith versus State, in Georgia Supreme Court regarding intrinsic evidence. At no point does their stories merge or provide context to the circumstances and events of the charged crime. There's a case that deals with, I just want to quote a paragraph from this case. It's Sanchez versus Villa, 341 Georgia Appeal 264 2017. The defendant, after making a purchase of drugs, was arrested by the Cobb County Police and charged with trafficking in cocaine. Prior to trial, the state became aware of a DEA investigation of defendant that had been going on for a year prior to his arrest. The DEA evidence was admitted into defendant's trial as intrinsic, which included a secret recording of defendant's phone conversation in which he discussed the sale of cocaine with a informant. The appeal court reversed on the ground that the state failed to establish before the jury that the drug purchase from which defendant was arrested was predicate transaction intended to fulfill the drug sale as discussed in the phone conversation. And because of this, the evidence lacked any demonstrated connection to the events on the night of the defendant's arrest. The court further held that the recorded conversation showed the defendant to be a potential drug seller, whereas his arrest showed him to be a drug purchaser, which this was contrary to evidence of a modus operandi because it failed to show a well-defined pattern of activity that was identical to defendant's behavior at the time of his arrest. It appears that the principles established in the case of Sanchez Villa would compel the same conclusion here, based on the fact I was arrested March 13th for possession, and the evidence of the drug transaction shows me to be a drug seller. This is the Court of Appeals.
You made that
Sir?
point times, Mr. Lynn. Do you have
Okay,
anything new to offer apart from that, Mr. Lynn?
no, sir, basic bottom line is that, the Court of Appeals deviation from the law, raised to the level of due process violation. And I think if you look at that, like I said, if you look at that, you would see that there's a high level of deviation from the law. And also the Fifth Amendment violation of it. Because if the evidence is not intrinsic, then they're independent crimes, which should have been on the presentment on indictment. And that's all I have to say about that.
All right, anything to say, Mr. Lynn?
As far as that,
As far as your habeas case, is there anything else you want to offer?
yes. The indictment not being returned in the open court.
Okay,
The foregoing authorities, Bowens, Brown, Zuger, all, Sampson, all these are Georgia Supreme Court cases of Georgia Court of Appeal cases where the court clearly showed that indictment must be returned in the open court, and the facts of the return must.
Mr. Lynn, I'm familiar with those cases. I know what they say.
Okay. So that's my argument on that the indictment wasn't returned in the open court.
Okay. What else?
Ineffective counsel. The
Okay.
trial court, although I was pro se, the trial court, restricted, my standby counsel. I was appointed standby counsel, but he restricted the counsel from sitting at the defense table and restricted the counsel from giving me unsolicited, information. He, basically made, counsel sit in the audience. And he, told him that he couldn't provide me with any information unless I asked for it.
I'm going to object as to relevance. That issue was raised on appeal and decided adversely to Mr. Lynn.
What about that, Mr. Lynn?
Yeah, well, the issue is, Your Honor, that, I still believe that, that I did not receive, counsel, I did not receive a fair trial or effective assistance of counsel.
Your Honor, if I may interject, Mr. Lynn chose to represent himself. There was a full Feretta hearing before the trial court. So that it's my understanding of the law that he can't even raise ineffective assistance of standby counsel because other than being standby, there is not a constitutional attachment there of any duty to that standby attorney. So as I said, that was raised on the Court of Appeals. The Court of Appeals gave him the benefit of the doubt and even assessed it like it was an ineffectiveness claim, and they found all of that lacked merit. So I would renew my objection as to relevance.
Mr. Lynn, if it was
Yeah.
considered by the Court of Appeals, and you represented yourself at trial, that argument is not going very far, I can tell you.
Well, Your Honor, from what I understand, once you are given appointment of counsel, once you receive standby counsel, then the potential of ineffective counsel attaches. Because I had received counsel, he was still my counsel, even though I chose to proceed pro se.
I don't agree with that. Once you decide to represent yourself, Mr. Lynn, the conduct of the trial is on you. And if there are any errors, you can't claim your own ineffectiveness.
Okay.
Standby counsel, that's just not going anywhere.
Your Honor, in the case in United States Supreme Court held in McCloskey versus Wiggins, they held that defendant's right to appear pro se does not include absolute bar on standby counsel's unsolicited participation.
Mr. Lynn, if the Court of Appeals considered this and ruled against you on it, this isn't going anywhere. Anything else, Mr. Lynn?
Sir? Yes, I
Any
want
other points to raise?
Yes. I just want to make this point right here. Okay, in Brooks versus State, was Georgia Court of Appeals case, it says that it does not mean that a defendant who elects to go pro se affirmatively or even impliedly waives all rights to legal advice and assistance from members of the bar. The fact that trial courts routinely appoint standby counsel shows that trial court routinely appoint standby counsel shows that the practicalities of the situation are understood. Here,
Mr. Lynn, do you have any other points to raise that you haven't raised?
yeah, I mean, young, basically what I'm trying to show is that my case has been treated with arbitrary and capricious conduct. That's my whole thing here today, that my constitutional violations are basically being violated because I'm not being dealt with within law. So I understand what you're saying, that it's been raised, it's been dealt with before, but it hasn't been dealt with within law, within prescribed law. Law that are on the books, been published and promulgated. That's my problem.
Okay.
Okay, as to the search warrant, I basically laid out everything I had to say in the brief. So I would ask that the court look at the brief
I will look at the,
regarding the, okay, is there any, by me not making any argument on the record right now dealing with the search warrant, could the state raise any argument after this now? I'm saying they would have to make an argument now dealing with the search warrant now, right? If they don't raise any argument, then
Mr. Lynn, I don't know what the state's going to do. And I can't give you any advice.
I'm not asking for any advice. I'm asking that if they don't make any objections right now, they can't come make any objections or file any documents after challenging anything that they're not objecting to now. So I'm not making any argument on the right here and now. I'm just asking that you look at the brief as far as my challenge to the search warrant.
Mr. Lynn, I'm going to look at the brief, but what the state does after you finish, there's no way for me to know that. And if you have some objection to it, you can raise an objection. But I can't give you advice about what's going to happen or what you should do if certain things happen. You have to present your case, and I can't help you with it.
Well, now, what I'm trying to say, would you be taking evidence after this hearing?
I'll be taking evidence. I don't believe the state has any witnesses today. I could be wrong, but I don't think so.
No, I mean, any further argument is what I'm trying to say, because
I'll consider any brief that gets filed.
Okay. All right,
And Your Honor, if I could clarify the state's or respondent's position, if this may help. Mr. Lynn, we're aware of your claims as you raised them in your petition and brief. The judge obviously has those as well. We've responded to them in a return and answer and asserted various defenses. I don't intend to call any witnesses today. I do intend to offer all of the records that went up to the Court of Appeals as evidence.
You know, I also want to point out the fact that I didn't raise this in the Court of Appeals. It was an error, but however, I think it was it's it's it was a substantial error to the point that this court may consider it, and that is a state witness, Kimberly Lambert, testified that I had participated in her prostitution by helping arrange a transaction. Uh, I think that this prejudice my trial of my character and raised the issue of unfair trial.
Mr. Lynn, did you represent yourself at the Court of Appeals also?
Yes. Yes.
And so that was an error that you could have raised, but you didn't?
Yes. Yes.
Okay.
You know, I don't, what you're saying, I don't know if this is something that you can consider, but I still want to put it on the record as far as, accumulative error. I'm gonna say although my traffic violation and arrest occurred during the time of the drug investigation at the hotel, it nor any evidence resulting from it could have substantially outweighed the unfair prejudice caused by the video, which showed the jury me being stopped, arrested, and in the back of a police car in handcuffs. The state's focus of this video was the content of my phone call, which has been established as blatantly contrary to state's evidence. I also asked that the court consider that due to the fact that my traffic violation and arrest for a probation warrant occurred prior to my arrest for the charged crime, that my prior arrest and resulting evidence has been held as extrinsic to the charged crime.
Okay, what else?
And lastly, I want to point out that the state raised the Court of Appeals and also the state raised the issue of my phone conversation. In this, they basically they fabricated the evidence, saying with the Court of Appeals say that I say in my phone conversation, which it does not. I don't say this because the record would show. And they supposed to say that I told someone on the phone to get in my room and remove my quoted shit before the police searched the room. However, I did not say anything about the police searching the room. However, it seems that the Court of Appeal considered this. Also, in my in my phone conversation, I tell the person who I'm talking about, I'm telling the person who I'm talking to on the phone that to remove my property from the room. And I tell them that the room is in another friend's name by the name of Tate. The friend's whose name is on the lease, name is Tate. But I tell them that Tate doesn't know that his name is on the lease. Now,
What's the point of all this, Mr.? What's the point of you telling me this?
the point that I'm trying to say is that the person who testified for the state got on the stand and said that he rented the room and that he was well aware of this. So by them introducing this evidence, it was contrary to the state's evidence. It was mirrorless. And so by them, it was no way that the jury could have inferred from the state's evidence and my phone call that this person was talking, that it didn't corroborate the state's evidence. You see, because the person who testified said he was well aware, yes, I rented the room. The tape, they was trying to say that basically I was referring to room 243 when I was saying, hey, look, get my stuff out the room. The room is in Tate's name, but he doesn't know that the room is in his name. But the person testified, said, yeah, I rented the room, and neither did they try to establish that the person who they had testifying went by the name Tate. So there was no corroboration of this evidence.
Okay, well, for whatever it's worth, I take your point. Okay, you said that was the last point.
Yes.
All right, so I take that means that you rest, Mr. Malcolm.
Your Honor, I don't have any. I don't have any questions for Mr. Lynn. All I have in the way of evidence, as I mentioned, is the record that went up on appeal to the Court of Appeals. It's a rather voluminous record. I don't have an electronic copy of it here in front of me today, but I would just like to make a record as to what those numbered exhibits are, if I could have the court's indulgence for just a moment. Judge, we got 13 exhibits, 1 through 13 for respondent. Respondents 1 is the entire clerk's record from Fulton County that went up on appeal. Respondents 2 is a pretrial motion hearing transcript from 2015. Respondents 3 is a Ferretta hearing transcript from 2016. Respondents 4 is another motion hearing transcript from 2016. Respondents 5 is the 4 volumes of the trial transcript. Respondents 6, 7, 8, and 9 are all respective different transcripts from different hearings that all took place in 2017 in Fulton County. Respondents 10 is the motion for new trial transcript hearing. Respondents 11 is the appellee's brief filed by Mr. Lynn to the Court of Appeals on his direct appeal. And respondents 12 is the, respondents 11 was the appellee's brief. That's going to be the district attorney's brief on appeal. And respondents 12 is actually the appellant's brief filed by Mr. Lynn.
Okay, so 11 is the appellant's brief?
Oh, excuse, I misspoke, Your Honor. I believe 11, as I have in my notes, is the district attorney's brief. So that would be the appellee's brief to the Court of Appeals.
Okay.
And 12 was Mr. Lynn, the appellant's brief. As we established, he was pro se, so he filed a brief with the Court of Appeals where he raised these enumerations of error. And finally, respondents 13 is the last exhibit. That is the Court of Appeals decision. We're making it part of the record as it was unpublished. So Your Honor will have that. It'll be part of this record. And we would move to admit all those exhibits into evidence, Your Honor.
All right, they're admitted.
Yeah, I have one more issue I want to point out. As far as
Well, hold on.
I did.
Mr.
Okay.
Lynn, it's not your turn. Mr. Malcolm.
Okay.
Your Honor, I don't have any other evidence. I would just like to quickly say, as I think I've alluded to, a lot of the claims Mr. Lynn has raised in his petition and talked about today were adjudicated adversely to him, raised on appeal. So he's very limited in what he can try to raise here in habeas to overcome that. It's got to be a change in the law or some sort of substantive change in the facts. I've not heard anything like that. Alternatively, if any of these claims are new, which I believe some in his petition were, we've asserted and continue to assert they are procedurally defaulted and that he has not shown cause and prejudice to overcome those. Obviously, because he represented himself by choice at trial and on appeal, he's rather limited in what he can raise to overcome any sort of default. I've not heard any argument or testimony that would even venture into that realm, Judge. So we would stand by our defenses as asserted. And I don't have any further evidence.
All right, Mr. Lynn.
Yeah, and I wanted to point out that as far as the search warrant, the reason I say that I did not receive a full and fair hearing is because the trial court say that he declined to hear my motion, my challenge to the search warrant on my motion for new trial, based on the ground that I had not raised some of the challenges before trial. And basically the hearing, the motion to suppress hearing before trial, I was not given notice for the hearing date. And I think that this was due to the fact that I was in custody at the time. And so my understanding that the first element of due process is notice. And because the court did not give me notice, then, and I objected to this on motion hearing that was on July 9th, 2015. The transcript was filed August 10th, 2015. My objections are on page 29 through 39. Then also,
Your Honor, for the record, that's respondents 2, I believe, what Mr. Lynn is referencing.
All right.
okay, then it was another hearing where the court on March 10th, 2016, the transcript was filed on May 27th, 2016. In this, if there's any misunderstanding about whether or not my objection was my position throughout the whole hearing, because the state tried to argue that that me and the court came into an agreement that I was okay with not being put on notice, and that wasn't the issue. The issue was that the court was persistent and it said that he wanted to move forward, and that's what I had to do, although I objected. And on March 10th, 2016, that's what page 24, the court would confirm that I did object, and that it was the understanding between me and the court that my objection was on the record, but he still wanted to move forward on that.
All right, Mr. Lynn, I have one question to ask you. Did you file a petition for certiorari to the Supreme Court after the Court of Appeals found against you?
Yes, the thing that I filed, but they said that I was time barred. The thing was with the Court of Appeals, I received the court's ruling on the 9th day. You see, you know that you get 10 days to file a reconsideration. So I received, and it's documented here at the jail, at the prison, that the prison gave me the court's ruling on the 9th day. I filed a motion for an extension of time, saying that I did not get the 10 days as all parties are given. And by the time the next day, before I put it in the mail, the time had expired. And so by the time they responded, the time had ran, my time had already ran in the Georgia Supreme Court. I tried to file a petition there, and they said that I was time barred, which they say I was time barred, but I was waiting on the Court of Appeals. I was really still legitimately in the Court of Appeals waiting on their ruling as to the motion for an extension of time.
Okay, it's a long answer for the, no, you didn't file your petition for certiorari?
Yeah, I filed it, but it was barred. They didn't accept it.
Okay, that's fine. All right, anything else for the hearing?
Uh, oh, yes, as far, yeah, also, regarding the search warrant, okay, let me read it. Due to my motion for doing my motion for new trial, the trial judge declined to consider my challenge to the search warrant on the ground that I had not raised some of the challenges before trial. I asked that the court consider the following along with the argument laid out in my brief. And Gordonello versus.
Mr. Lynn, I think
Sir.
you're repeating yourself. You said this a little while ago. You also
Yes, but
told
it was,
you were
this is
gonna
another
rely on
point
your
that I
brief.
wanted to.
Mr. Lynn, I'm kind of running out of patience here. I mean, you're repeating yourself. I'm trying to give you a chance to raise all of your points, but I only need to hear it once.
I understand that, yeah, and I was just getting to the point of the issue about the Court of Appeal, the trial court declining to hear the challenges to the search warrant based on the ground that I had not raised them before trial. Here I have a United States Supreme Court case that's basically states something contrary to that. I just wanted to
And that's in the brief you filed already?
no, this point here that I was just going to make is not in the brief.
So when you told me before that you were going to rely on your brief and with regard to the search warrant, that wasn't accurate?
No, this part right here, this why I just looked over and saw that it was just one part that I left out.
Okay, just briefly, tell me what you want to tell me.
Okay, in Gordonello versus United States 357 US 480, the court held that I'm just reading from this. Where the defendant challenged sufficiency of the warrant for his arrest on ground that complaint on which warrant was issued was inadequate because complaining officer relied exclusively upon hearsay information rather than personal knowledge in executing the complaint, and on the ground that complaint was defective and that it in effect recited no more than elements of charged crime. The fact that in the district court and in court of appeals, the defendant relied primarily, if not entirely, on the first ground did not prevent the defendant from relying in the Supreme Court on the second ground, which raised simply a question of law as to the sufficiency of the complaint. That's my point, Your Honor. The trial court saying that because I did not raise the challenge before trial, that doing my motion for new trial, that he would not consider it. But here, like the Supreme Court said, because it's only a question of law. It's not a question for the jury. So it can be raised after trial.
Okay. All right, is that it?
Yes.
All right, both sides have now rested. Briefs have been filed by both sides. There's no need for any further briefing. Mr. Malcolm, you're going to submit the record to the court reporter.
Yes, Your Honor.
The exhibits for inclusion in this record.
Yes, Your Honor. Those exhibits enumerated 1 through 13. We'll get those. They're rather voluminous, but we will get them to the court reporter as soon as possible. Yes, Your Honor.
Okay. I will ask each of the parties to submit a proposed order within 30 days. Is that enough time?
A proposed order?
Proposed order, yes. Mr. Lynn, is 30 days enough time for you to do that?
Yes.
I'm assuming, Mr. Lynn, your proposed order would be that the habeas petition be granted. I'm assuming that the Attorney General's office will submit a proposed order that the habeas corpus petition be denied. And so you each get a chance to submit a proposal to the court within 30 days.
Judge, is that 30 days from our receipt of the transcript from today's hearing?
If that's what you're asking for, yes.
Yes, Your Honor.
Okay, 30 days for each side to submit a proposed order after the receipt of the transcript of the hearing today.
Okay, Your Honor, would you take into consideration, I filed as an exhibit, the state's bench brief in which they claim it's their ground for the submission of the uncharged crimes.
Isn't that in the record of the case that the Attorney General's office submitted, Mr. Lynn? Isn't it already in
No,
the record?
it's not. It is not. It wasn't filed into evidence, but it's the bench brief that the state used. The state never did make any argument on the court. There's nothing in the transcript which
Your Honor,
explains.
it's a 2-page bench brief that he submitted a copy to me. If he wants to submit that to the court, I won't have an objection.
Okay, you can submit that, Mr. Lynn.
Okay, so okay, well, it's filed with my brief as an exhibit.
If it's already in the record in this habeas case, then you don't need to do it again.
No, I'm not asking to read. I'm asking him, is it something that you can consider?
Well, it's something that I'll look at. Whether it changes my opinion is another matter, but certainly something.
No, I'm not asking. I'm just asking, is it something that you can consider? But I understand that I don't know the law
Yes.
like that, so.
Yes, I can consider it.
Okay. All right, that's all I have.
We'll be in recess in this hearing with the transcript to be filed, followed by the proposed orders in 30 days. We're in recess.
Thank you, Your Honor. May I be excused?
Yes, I believe that concludes the calendar. So yes, sir.
It does. I believe so. Thank you,
Yes.
Judge.
Okay, thank you.